This video will guide you through how VisionWorks, our next-generation life planning software, can take your financial planning business to the highest level.
Thank you for your time. We're going to be talking about wills and estates today. And the first thing that I want to do is actually a quick run through of the layout of the will page and also the estate output, just so that you're familiar with them, particularly if there are any advisors who are looking at VisionWorks for the first time. So you'll notice the navigation pane down the left, and I'm just going to go to the will page and run through a few things for you. First of all, you'll notice up here, this is the area where we locate documents. So there are some things on the will page that aren't directly related to a will, but they are related to estate issues, expenses, things like that. So it's a convenient place just to organize all of it. And you'll notice under documents, for example, there's a question as to whether or not people have a recently updated will. And we'll come back and talk about that in a couple of minutes. And then some questions about, powers of attorney and so on. Then what you'll see is an area for expenses. And while they're again not noted in a will, they're just a convenient location to put in terminal charges like funeral expenses and legal and accounting fees and so on. I want to spend a minute here on dollar allocations. So dollar allocations are specific amounts that you're going to leave to somebody. I bequeath to my niece Susie $25,000. And it doesn't matter if I die today or if I die 20 years from now, she still gets $25,000, obviously with different purchasing power. And if we open up the beneficiary list, you'll see that the only people noted in the list are those people who are parties to the plan, in this case, Bill, Sue, and Bill Jr. So if you want somebody to specifically show up in the printed report as receiving a dollar allocation, you have to add them to the About page. And the reason for that is very simple. There are different tax and estate rules around different beneficiaries and so on. So if you want them to show up, you have to add them to the About page. If it's not important that they show up, but just the dollar amount itself, since it's a charge to the estate, then you can use non-party. And a good example of that might be, for example, grandparents that might be leaving $25,000 to each of 6 children or grandchildren. You may not want to necessarily create the 6 grandchildren on the About page. You may simply use non-party, but in this case, it's only one non-party that's available. So you would have to make the 6 times 25, the $150,000 would be the amount that the non-party would get. We need to talk about percent allocations. So this determines the residue of the estate. And the reason that the residue is treated in terms of percents is that we don't know when we're going to die. We don't know what the value of our assets will be. We don't know what our terminal taxes will be. We don't know what our probate fees will be, and so on. So it's virtually impossible to say at death, I will bequeath whatever, other than a dollar allocation, obviously. So the way dollar allocations of the residue are handled are just simply as distributions of the residue based on the percentage value after, whatever the residue might be, after accounting for things like terminal taxes and so on. So the question then is, what makes up the residue of an estate? So I want to remind you that assets such as TFSAs and RSPs are actually trusts. And because they're trusts, we're able to designate beneficiaries for them. But we can't designate beneficiaries for bank accounts or non-registered portfolios, setting aside seg funds, simply because they're not trusts. And to be able to designate beneficiaries for non-registered portfolios, we would literally have to have a beneficiary designation for every asset in the portfolio. And every time we bought and sold a stock, we'd have to complete beneficiary papers. So that's clearly unmanageable. So the result is that on death, whatever's in the bank accounts and non-reg portfolios, that becomes the residue of the estate. Then we have the expenses of the estate, terminal taxes, probate fees, funeral expenses, and so on, charged against that. And then whatever's left over is distributed according to percent allocations. And then the final thing that we have to remember about a will is that it designates beneficiaries for specific assets. And in this case, you can see that I have a cottage in Bill's name. We'll come back and talk about that in a moment. So I want you to imagine in this particular file that in his former relationship, this is a second marriage blended family situation. In his former relationship, his previous wife ended up with the house. He ended up with the cottage. It's his asset. So we designate beneficiaries for assets. And in this case, Sue's the beneficiary. But I also want you to notice that if I close the will tab, that what I can also do is go to the joint tab. So just notice that assets are on the tab of the owner. So the cottage is on Bill's tab. He's the owner. When we go to the joint tab, you don't see the cottage, but you do see 6R Street. Now, 6R Street is a joint tenant asset, and as such, it's not part of the will. However, we put it here, joint tenant assets, on the joint tab, again, just out of convenience, a place where we can organize all of this. And the reason this is important is because as a joint tenant asset, you can see the add and delete buttons are disabled when we're on the JTWROS tab, because Bill's half of the house must go to Sue and Sue's half must go to Bill. However, for all assets, what you'll also see is a contingent beneficiary tab. So when you're modeling wills and you see assets, you're not only going to designate the beneficiary according to the terms of the will, but also the contingent beneficiary. And the reason for this is when we do life insurance calculations. So in our normal course of the plan, the expectation is that Sue is going to outlive Bill. So Bill's half of the plan or of the house will go to Sue. But in the case of a joint tenant asset like the house, what happens is when we do a life insurance calculation for Sue, we have her dying today, predeceasing Bill, so that when it comes to Bill's will, what the software does is it says, well, according to the will, it's supposed to go to Sue. Wait, Sue's already dead. So it now will go to the contingent beneficiary. So whenever you're modeling assets, you need to model both the main beneficiary and the contingent beneficiary so that we can do life insurance calculations for each of Bill and Sue. So let's go down to the estate tab and we'll get oriented to it. It's on the solutions page, the estate tab. And you'll see a beneficiary table. And then under that table, you'll see a list of different assets. And as you'll see later, if we click a different beneficiary in the table, then you'll see the list of various entries that will go to that beneficiary. So in this case, everything is going to Sue. And we can click these little edit buttons and we see that she's going to get Bill's half of the house. There's no money projected to be left in the joint non-registered portfolio. She's going to get the cottage. She's going to get some art that Bill owns. And then she's going to get the remaining funds in the RRSP and TFSA. And also there's a life insurance policy that Bill owns for which she's the beneficiary. So again, when you select a beneficiary, the lower table will tell you what the projections are for that person, what they're going to receive. And then if we click the show table button, we see some calculations here. The liquid assets for Bill are none. And the reason for that is because in this particular plan, Bill does not have his own bank account nor a non-registered portfolio. In this particular plan, all bank accounts and portfolios are joint. So on death, then automatically Bill's half passes outside of the will and goes to Sue. You'll also see a tax calculation. So if you click this button, you'll see the calculation for Bill's life expectancy year. Also you can, of course, look at the provincial calculation and so on. So this just gives you an opportunity, and we'll see this later, to see the effect of leaving assets to someone other than Sue and therefore triggering capital gains. Probate fees, of course, are based on the different assets and also the province where those assets are located. So we're calculating probate fees. And basically what this says is that Bill has no liquid assets. He has terminal income taxes to pay, estate administration taxes to pay, probate fees, the total of which are $38,000. And because there are no liquid assets in his name and charges to the estate of $38,000, then the residue for distribution is $38,000. And based on the will's percent allocation and also the fact that Sue's the executor of the estate, all of that percent allocation is going to end up as an expense that Sue has to take care of. So generally, if we look at this, we see that Sue's going to be in great shape, about a $4 million amount to be received in total on Bill's death. The one other thing that I just want to touch on very briefly are some assets where the beneficiary for them is designated within the asset itself. So if we go to portfolio accounts, the TFSA beneficiaries, we see that Sue is Bill's beneficiary of his TFSA. And in this case, we have a transfer selected. So the funds in it will transfer over to Sue. Same thing with an RSP, Sue's the beneficiary. And the same thing with the insurance policy, Sue's the beneficiary. And I just want to point out that this is the underlying assumption, to my knowledge, of all other planning software, that on Bill's death, everything is going to Sue, and then on her death, the assets will go to Bill Jr. And be taxed. But on the transfer to Bill, from Bill to Sue, of course, it's a spousal rollover, so no taxes apply. And we'll, of course, be talking a lot about that a little bit later. So the first thing I want to do is just go back to the will page, and I actually want to start by deselecting. Oh, sorry, forgive me. I want to do something else first. My apologies. In the software, we can create unlimited what-if scenarios. We call them solutions. So what I want to do before I deselect the will tab is I just want to click copy and name this no will. Bill. We'll set that as the plan, save it, and now we'll go back to the will page. And what we'll do is we'll deselect the will checkbox. Now, it may well be that people have a will, and that's why we say a recently updated will, because it's very possible that a will could be out of date, could it be created in a different province. There are all sorts of legal possible issues. So I think it's really intended to make sure that people have an updated will, not just a will that, might be from 20 years ago. So notice when we deselect this no will, that all the will features are disabled. The tree view is disabled, so we can't create beneficiaries for assets like the cottage. The dollar allocation, percent allocation tabs are disabled. We can't put in the percent residue of the estate. We can still, of course, put in things like expenses. So let's go down to solutions and let's have a look. And what happens is that VisionWorks will apply provincial intestacy laws. So any assets that are joint tenant will go to Sue, and otherwise the value of the remaining assets will go into a pot, so to speak. In Ontario, a spouse receives the $350,000 preferential share. That's right off the top. And then the rest of the assets will be split 50% to Sue and 50% amongst the surviving children. In this case, only one child. So Sue gets the assets in the RRSP and TFSA because the beneficiaries for them are designated within those assets. She gets the life insurance benefit. But as far as the residue of the estate is concerned, the value of the cottage, the value of the art that are in Bill's name, what happens is it's totaled up. $350,000 is taken off the top. We get the remainder, and then it's split 50% to Sue. And because there's only one child, 50% to Bill Jr. So the software is going to properly account for, provincial intestacy laws. And my recommendation to you when you're working with a client is to uncover these issues. And I'll just show you this double set of graphs on the left. What I can do is I can show in a normal situation, by that I mean if there's a will in place and it's kind of the standard will, everything Bill has goes to Sue. In a normal situation, we can see Sue's the beneficiary. The government doesn't get too much. It's a spousal rollover. But where there's no will, then Sue's getting much less because some of the assets are going to Bill Jr. and the government's getting a whole lot more because when the assets go to Bill Jr., then there are taxes that apply. So if planning is about learning and decision making, if somebody doesn't have a will, I recommend you start off by modeling no will, but then you create a new solution. And what you do is you go in and you model the terms of the will with them as they expect it to be. They still have to go off and have the will executed, but we'll at least model things the way we expect them to be. And the reason I suggest doing that is because it's going to have an impact when you go forward and do the plan. So I would do a plan based on a will exists, even if it doesn't, but make it a priority for them to go out and get that will in place. So what I want to do next is I'm going to go back to our wills and estate solution, and I'm going to create a copy of it, and I'm going to call this Cottage to Bill Jr. And for those of you who are familiar with what we do in this whole area, I consider this to be an extremely important planning feature in the software. And again, to my knowledge, other software doesn't integrate the terms of wills. And of course, the issue is that in Canada now, we have an extremely high divorce rate, especially amongst the so-called silver set, and lots of clients who are in second marriages and have blended families. And this can create some very important estate issues. And I believe in the absence of the ability to model the terms of wills, that many plans that are being produced are anywhere from slightly to potentially extremely misleading. So again, if we go back to the About page, I'll just remind you about the family tree. And normally, if a family has children in common, then you would see them coming down from that middle shared dot. Bill Jr. would come down from that dot. So what I did was I just clicked on that joining line, and then I moved it over to Bill to illustrate that Bill Jr. is Bill's son from a previous marriage. Now that I've clicked it, I need to resave. So in this case, we're talking second marriage and blended family. And what Bill says is, Sue, you get my half of the house, you get all the funds in the TFSA, the RRSP, you get insurance and so on, but I can't cut Bill Jr. out of the will. I have to leave him something, so I'm going to leave him the cottage, which is in Bill's name. So we can go to the cottage, select the beneficiary, and then change the beneficiary from Sue to Bill Jr. And of course, what happens is capital gains are realized, and that creates a major issue for the estate. So if we go down and now look at solutions in the estate output, instead of the residue being just 38,000 negative, it's over $500,000 negative because of the capital gains on the cottage. And if we open up the taxes, we can see the capital gains, quite clearly. So those are the things that I wanted to cover today. And I want to, of course, thank you for your time.
Book a demo. We'd be happy to show you more of VisionWorks' incredible features.